Other noteworthy things that I recall from tonight are that in Article 4, there was some crazy rules, some crazy time rules. One was a 13-day time rule. So there was a 13-day time rule in Article 4. It was basically when a rebuttal was 13 days, and then there was a 15 days with it. It was like a 30, 15, 30, 13, then 15 for something about a rebuttal in an Article 4 thing. So you see rebuttal, Article 4, it was a 13-day rule. Okay, there's also a crazy 5 business day rule in Article 4. It's in support, family court, Article 4, number 440, and it says that, I don't even know what this is talking about, but I definitely just saw something about a 5 business days. Okay, here we go. Where such direction is for child support and paternity has been established by a voluntary acknowledgement of paternity, the court shall inquire whether the acknowledgement has been duly filed, and unless satisfied that it has been so filed, shall require the poor clerk to file the clerk to file the acknowledgement within 5 business days. So this is actually something about the clerk doing something, and it's 5 business days. Okay, so basically the beginning of this article is talking about whenever there's a proceeding referred to the family court from Supreme Court, or under 5B FCA, 5.4 or 5A of this act, shall direct the payments of support, either child support or combined child and spousal support, collected on peoples who are getting enforcement services pursuant to the social services law, or people on welfare. Those people, when you do a support order, the court has to make it so that it's paid directly to support collection unit, or shall be enforced pursuant to 5242 of the CPLR, which is, I think, income deduction order. Or, and in either case, in either case, it says, except as provided herein, be effective. And in either case, okay, so it's either got to be, if it's DSS is involved or people are on welfare, it has to be paid to the social services support collection unit thing. And if it is, so that's one side. If it's welfare or receiving support enforcement services, it has to be through support collection unit. But if it's not either of those things, it can be that it has to be either through support collection unit, or it can be by income deduction order, because that's 5242 of the CPLR's income deduction order. Then it says that in either case, it's effective when the petition is filed. So it's effective retroactively to when the petition is filed, or if they're in public assistance, when the date of their eligibility was. Okay, FCA 447 says, A, in the absence of an order of custody or visitation issued by Supreme Court, the court may make an order of custody or visitation. The court may make an order of custody or visitation pursuant to the DRL, requiring one parent to permit the other parent to visit the child at stated periods of time without an order of protection, even where the parents are divorced and the support order is for a child only. B, any order of the family court under this section shall terminate when the Supreme Court makes an order of custody or visitation concerning the kids, unless the Supreme Court continues the order of the family court. And actually, I believe says the same thing for a support order. Okay, 440. By now we all know that when the people are on welfare, it's retroactive to the date that they were eligible to be on welfare, public assistance. Okay. When a child is receiving public assistance or the order of support is being enforced or is to be enforced pursuant to 111G SSL, the court shall establish the amount of the support and notify the parties that such amount shall be enforced pursuant to the CPLR to 5241 CPLR, or in such periodic payments as would have been authorized had such an execution been issued. In such case, the court shall not direct the schedule of repayment of retroactive support. Voluntary acknowledgement, the court shall inquire if the been duly filed, and then this goes into the 5 business days thing. Okay, 440. By now we all know that when the people are on welfare, it's retroactive to the date that they were eligible to be on welfare, public assistance. Okay. When a child is receiving public assistance or the order of support is being enforced or is to be enforced pursuant to 111G SSL, the court shall establish the amount of the support and notify the parties that such amount shall be enforced pursuant to the CPLR, to 5241 CPLR, or in such periodic payments as would have been authorized had such an execution been issued. In such case, the court shall not direct the schedule of repayment of retroactive support. Voluntary acknowledgement, the court shall inquire if the been duly filed, and then this goes into the 5 business days thing. So basically what this is saying, right, if any time public assistance or support enforcement is involved, then you basically cannot have a support order that doesn't involve the support collection unit. The only way that you can avoid the support collection unit is that you've never received public assistance, the child has never received public assistance, and in that case, there has to be an agreement, and then it can be enforced pursuant to like income execution. Unless, clear, this is exactly what it says. When the court issues an order of child support or combined child and spousal support on behalf of persons in receipt of public assistance or 111G services, the support collection unit shall issue an income execution immediately. The support collection unit shall issue an income execution immediately for child support or combined support, and shall issue an execution for medical support enforcement. Unless. Now, the only way this can be avoided is if the court finds and sets forth in writing, okay, not on the record, this has to be in writing, okay, that there is good cause not to require immediate income withholding, or 2, when the child is not in receipt of public assistance, a written agreement providing for an alternative arrangement has been reached between the parties. Such written agreement may include an oral stipulation on the record resulting in a written order. For the purpose of this paragraph, good cause shall mean substantial harm to the debtor. The absence of arrearage or the mere issuance of an income execution shall not constitute good cause. When an immediate income execution or an execution for medical support enforcement is issued by the support collection unit, such execution shall be issued pursuant to CPLR 5241. Except that if there are provisions relating to a mistake of fact, default, and any other provisions which are not relevant shall not apply. Provided, however, that if the SCU makes an error in the issuance that's to the detriment of the debtor, they have 30 days after notification by the debtor to correct the error. Where permitted under federal law and where the record of the proceedings contains the information, such order shall include on its face the Social Security number, name and address. Where the court determines that, oh my God, this article is horrible. Where the court determines that there is good cause not to immediately issue income with execution, or where the parties who are not on public assistance and have never been on public assistance agree to an alternative arrangement, the court shall provide expressly in the order of support that SCU shall not issue an immediate income execution, because they basically do it for everyone. So if the court doesn't want them to do it, the court has to specify in the order that they're not supposed to do it. Notwithstanding any such order, the court shall issue the income execution when the debtor defaults. So even if the court told them not to, if the debtor defaults, they got to do it. Okay. When an income execution for support enforcement is issued pursuant to this paragraph, such income execution shall supersede any income deduction order previously issued for enforcement of the same support order pursuant to subdivision C of 5,242 of the CPLR, whereupon such income deduction order shall cease, stop, cease to have further effect. Now, this paragraph, it says it's other than in people receiving public assistance or the 111G thing, all right? The court shall issue an income deduction order at the same time which it issues the order of support. The court shall enter the income deduction order unless the court finds and set forth in writing, 1, reasons of good cause not to require immediate income withholding, or the agreement between the parties. Okay. And it can be an oral stipulation that results in a written order or a written agreement. And this good cause means substantial harm to the debtor. Then it goes into the Social Security thing, name and address of employer, doesn't invalidate the order if they don't include it. Court shall make provisions for health insurance benefits. So this is all the same thing. Now I'm moving on to, this is subdivision 4, and I don't even know what section I'm in anymore. Okay, I'm still in 440. So subdivision 4. Any support order made by the court in any proceeding under 5B, pursuant to a reference from Supreme Court under 251 DRL, or under Article 5 or 5A, shall include on its face a notice in printed, typewritten size, at least 8-point type. It's kind of small. 1, informing respondent willful failure can result in 6 months of jail for contempt of court. And B, informing parties of their right to seek a modification upon a showing of 1, substantial change circumstances, 2, 3 years have passed, or 3, gross income change by 15%, unless the parties specifically opt out of that paragraph. Okay? If pursuant to a validly executed written agreement or stipulation, then that basis does not apply. Then it goes on to the court shall direct that a copy of any child support order or combined child and spousal support order issued by the court after October 1st, 1998. So in any proceeding pursuant to a reference from Supreme Court under 251 DRL or under the provisions of 4, 5, 5A, or 5B of this act to be promptly provided to the state case registry established pursuant to 4A of 111B SSL. Sub 6 says, any order of support made by the court shall provide for health insurance benefits pursuant to 416.